Good evening. As board secretaries, I'm calling this is the reorganization meeting of the West Windsor-Plainsboro Regional School District for the period January 2017 through January 2018. In accordance with the state sunshine law, adequate notice of this meeting was provided by sending a notice of the time, date, location, and to the extent known, the agenda of this meeting to the Princeton Packet, the Times, and West Windsor and Plainsboro Public Libraries. Copies of this notice have also been posted in the board office, filed with Plainsboro's and West Windsor's townships clerks, and placed in each of our schools. It's my satisfaction to thank the community. This year we had 10 members of the community running for the 3 spots in the 2 townships, and it's my pleasure to announce that with us tonight are the 3 winners. Carol Hertz, who will be sworn in as a member for West Windsor, Louisa Ho, who will be sworn in again as a member for West Windsor, and Taylor Jean, who will also be sworn in again for Plainsboro. Each of you, 3 of you, have the oath of office in front of you. We will take you consecutively in alphabetical order. Carol, if you would start.
I, Carol Hertz, do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of New Jersey, and that I will bear true faith and allegiance to the same and to the governments established in the United States and this state under the authority of the people, so help me God. I, Carol Hertz, do solemnly swear or affirm that I possess the qualifications prescribed by law for the office of a board member of education, and that I will faithfully, impartially, and justly perform all the duties of that office according to the best of my ability, so help me God.
Thank you. If you'd sign and pass that over. Louisa?
I, Louisa Ho, do solemnly affirm that I will support the Constitution of the United States and the Constitution of the State of New Jersey, and that I will bear true faith and allegiance to the same and to the governments established in the United States and the state under the authority of the people. I, Louisa Ho, do solemnly affirm that I possess the qualifications prescribed by law for the office of member of a board of education, and that I will faithfully, impartially, and justly perform all the duties of that office according to the best of my ability.
Thank you, Louisa. If you would sign and pass that down. Taylor?
I, Taylor Jean, do solemnly swear that I will support the Constitution of the United States and the Constitution of the State of New Jersey, and that I will bear true force and true faith and allegiance to the same and to the governments established in the United States and in this state under the authority of the people. So help me God. I, Taylor Jean, do solemnly swear that I will possess the qualifications prescribed by law for the office of member of a board of education, and that I will faithfully, impartially, and justly perform all the duties of that office according to the best of my ability. So help me God.
Thank you, Taylor. If you would sign. Thank you. All 3 of you are now legitimate members for this school year. The rest of you already have your legitimacy from your prior elections. At this time, I will accept nominations for President of the Board of Education.
Hi, I nominate Anthony Flares for President of the Board.
Okay. You have your ballots in front of you, I hope, at this time. Have they been passed down to each of you? If you would indicate your vote and then pass them to me. We have 7 votes for Anthony Flaherty's, and Carol Holtz abstains, and of course, Rachel is absent. I now turn the meeting over to President Flaherty.
Thank you. All right, now I'd like to have nominations for Vice President.
I'd like to nominate Michelle Case.
Any others? Okay, Larry will gonna pass the ballot down. When you're done, just pass them over to, we'll pass them over to Larry.
There are 7 votes for Michelle Case, Carol Hertz abstains, and Rachel is absent.
Thank you. Congratulations. All right, now we have a number of items that are just continuation of our regular doing business. Can I have a motion on items Roman numeral 7 to 32?
Actually, if I could interrupt you just for a moment of another formalization. We're kind of doing a belts and suspenders tonight. Each of you will take a copy of the ethics and sign the sheet, which will be passed down. It's kind of a double belts and suspenders thing because later in the evening, our board attorney will be addressing you with the annual ethics training. We usually don't have it at the same time, so we're doing both things tonight.
So we need, Larry, we need 2 more copies.
Oops.
Is there a place to sign this?
It's also attached to it's also attached to the packet that I left for all of you as well, so we don't have.
Getting
Oh,
double.
signing that sheet as it comes
Yeah.
up.
There were 9 when we started. Did they stall it someplace?
Oh, sorry. You're right. Sorry. Not used to it.
If anyone has a problem signing that they received one, either directly from me or in the packet that Mark has distributed, please indicate that, and we will do something about it immediately. Otherwise, I will expect your sign that you've received it, and then the meeting can proceed. Nobody said they don't have it, so we're good.
All right. Okay, so I'll need a motion on items 7 to 32. Dana and Isaac.
I would like to vote separately on item
Item 20.
and 22, and 28.
Okay. 2022.
And 28 was the request.
Just to be sure, we're talking about the curricula, the Princeton packet, and the nursing services. Okay. Well, I'll have a motion on all the items except for 20, 22, and 28. Right,
Okay.
Isaac and Dana, any questions?
Mr. Chang?
Yes.
Ms. Hertz? Ms. Ho?
Yes.
Ms. Krug?
Yes.
Mr. YZ Jean?
Yes.
Mr. Taylor Jean?
Yes.
Ms. Case?
Yes.
Mr. Flores?
Yes.
8-0.
Do we want to carry these three individually?
Are you okay with all three of them,
You want-
Carol, or do you want individual? She requests individual.
All right. So I have a motion on item 20. Louisa and Taylor. Any questions, discussion?
Mr. Chang?
Yes.
Ms. Hertz?
No.
Ms. Ho?
Yes.
Ms. Krug?
Yes.
Mr. YZ Jean? Mr. Taylor Jean?
Yes.
Ms. Case?
Yes.
Mr. Flores?
Yes.
7-1.
Okay, can I have a motion on item 22?
I think that we should publish the agenda in the WWP info because that is distributed to every resident in Plainsboro and West Windsor.
Let me just get a motion first, and then.
Okay.
You see the motion for
Yeah.
a second, then
And then I'll,
discussion.
then we'll have discussion.
Okay.
No problem. All right, so a motion on number 22, Louisa and YZ. Okay. Any discussion?
Yes, I don't read the Princeton packet. I don't know how many people do, but the WWP info is distributed to every household in West Windsor and Plainsboro. So I think that the agenda should be printed in that newspaper.
Just a point of order. As many of you know, the agenda is not printed. Notice of the meeting is
Okay.
printed. Unless you're suggesting that future business, the agenda be printed.
Okay, I think there is an issue with the frequency of the paper.
I was about to,
Okay.
may I, is it a, I apologize, I'm not familiar with the publication. Is it a daily paper or is it a weekly?
Bi-weekly.
It's biweekly. Biweekly.
So
Yes.
It's semi-monthly.
It's semi-monthly.
Yeah.
Okay, so for the official board newspapers, of which we have to have two, under the Open Public Meetings Act, they do have to be, at least one has to be daily publications, and it's preferred that there be two daily publications so that it reaches the target readership, under the Open Public Meetings Act as it currently is written.
Okay.
Okay, well, I don't read the Times or the packet, so. Anyway.
Yeah, packet is not sent to Plainsboro residents. However, the West Windsor Plainsboro WWP info is only distributed to single-family houses, not apartments. I asked the Rich Line.
Okay. Any other discussion on the motion?
Mr. Chang?
Yes.
Ms. Hertz?
No.
Ms. Ho?
Yes.
Ms. Krug?
Yes.
Mr. YZ Jean?
Yes.
Mr. Taylor Jean?
Yes.
Ms. Case?
Yes.
Mr. Flores?
Yes.
7-1.
Okay, and now item 28, the nursing services plan. Could I have a motion for that? Isaac and Dana. Any questions, discussion?
I have not seen the plan, so I cannot vote on it.
Okay.
Mr. Chang?
Yes.
Ms. Hertz?
Abstain.
Ms. Ho?
Yes.
Ms. Krug?
Yes.
Mr. Weisey-Jean?
Yes.
Mr. Taylor-Jean?
Yes.
Ms. Cash?
Yes.
Mr. Flares?
Yes.
701.
Okay. Okay, that brings us now to our regular meeting, and the superintendent would like to make some comments.
Good evening, everyone, and welcome back and Happy New Year. January is School Board Recognition Month. At this time, I'd like to thank all 9 members of the WWP Board of Education for their commitment and dedication to the more than 9,700 students in our district. On behalf of the administration, the staff, and our community, please enjoy the book, Sing for Your Life, about a young man whose life was positively changed by his teachers. Also, just wanted to note that at the last public board meeting, I indicated that there is a meeting on January 18th with the West Windsor Planning Board regarding the Howard Hughes Corporation. After our meeting concluded at the end of the next week, we learned that Howard Hughes did not submit their documentation in a timely manner, and as such has been removed from the January agenda. So as of right now, there will not be, there's still a planning board meeting, but there will not be a presentation by the Howard Hughes Corporation at the January 18th meeting. And I also just wanted to note that at the January 24th meeting, representatives from our strategic planning team, in particular Judy Wilson, who's the strategic planner that the district hired, will be making a presentation based on strategic goals. In the audience are 2 of our student reps that were both participating, so I'd like to thank Dylan and Haley for joining us during the strategic planning process. Once the Board of Education reviews and approves the goals that were created, we also, at that point, will then create strategic planning teams for each goal. So to develop a planning document to actualize each of the goals that have been identified. Thank you.
Okay, that brings us to our student representatives.
Hi, I hope everybody enjoyed their break, and I'd just like to start off with a quick thank you for allowing me and my counterpart Dylan to be a part of the district strategic core planning conference on December 15th and 16th. We both took a lot out of the experience and appreciated being able to shape the direction that our district will move in the next coming years. All right, and this year our theater department will be performing 9 to 5 as a musical. This show will take place in the beginning of March, and our cast and crew is already working diligently. Our student council will be holding its annual winter event in a few weeks. Because of its huge success last year, we have decided to put together another dodgeball tournament. Teams of 8 will compete to come out on top, but also for a best uniform prize. All proceeds will be donated to charity. And on Friday, December 16th, choir held its annual winter concert that included chorale, women's choir, and chamber choir. At the very end, it is tradition for the choir to sing Hallelujah and Daddy Boy, and at that time, the choir alumni joined them on stage to sing with them. And this past week and a half, South students have been spending time with their families and taking a break from schoolwork thanks to the no homework policy. But many seniors like myself have spent a lot of time polishing the finishing touches on their college applications, all due January 1st.
Thank you.
Good evening, board, and welcome to the new year. North, as the new year begins, has fully engaged in its activities once again. Starting on the 6th, the improv group puts on their first performance of 2017. Then on the 27th, the Literary Magazine Club puts on their first poetry slam of 2017. And immediately on the day after, the 2018 Class Council puts open their district-wide Pro Skate fundraiser. Tomorrow, this Wednesday, comes a very important lecture for many students, particularly in the junior class, which is the Junior College Planning Night, which expects high attendance. Simultaneously, North Sports have enjoyed similar successes as they have in previous years. And most prominently, the girls basketball team had won a home-hosted tournament called War of the Worlds. I think that featured 68 schools. And finally, the Midnight Inventors High School North's robotics team is opening up their first workshop at High School North this Saturday the 10th at 3 p.m., which is open not only to the Midnight Inventors, but will also be used in actual school courses. Thank you.
Thank you. Okay, now we want to ask Mark Toscano, our board attorney, give a presentation on Board of Education ethics training, or ethics.
Chase the student representatives out as soon as they said we were talking about ethics. Good evening, everybody. Happy New Year. Welcome back. It has been another interesting calendar year with the School Ethics Commission. As we started doing this, our firm started working with the board last December, late November. There was a lot to do, a lot to get started with, so we actually didn't get a chance to do the ethics presentation last year until I believe it was the March meeting. But we do recommend that this training, if the board wishes to avail itself to the training that we offer, be done generally at a reorganization so that it's on a calendar and it flows through. Like last time, there's a cover sheet that we would ask that you please sign and return to the board secretary so that there is a record that you were here, you heard, and you received a copy of the information. Like last time, there is the packet is divided into 3 tabs. The first tab is the slide presentation, which I will go through momentarily. The second tab is the Code of Ethics, the 10 provisions. And the third tab is the School Ethics Act itself. If anybody's having trouble sleeping at night, this will help. Without further ado, and of course I welcome questions as always as we proceed with the presentation. We're good, just as a roadmap, I would like to talk about, as a review analysis of the School Ethics Act itself, go through the 10 tenets of the Act. It's one thing to sit and talk about them in a vacuum. It's another thing to go through them and to understand what each one stands for, what the purpose behind each tenet is, what a violation has been found for each tenet, and what the School Ethics Commission looks for. Always a hot topic is negotiations and what I like to call the chain of command, who can and cannot be a part of those discussions. If you go on to the School Ethics Commission's website and you go to their advisory opinion section, the page with the most advisory opinions has to do with who can and cannot participate in negotiations. Very happy to say that we will not be negotiating this year, as all groups are resolved and in the midst of contract negotiations, but it's always good to kind of understand that, those provisions. There has also been a series of new guidance issued within the last year that has changed some prior ethics decisions and in fact has pulled back. If you remember in March, those of you that were here, which is everybody, this is your first time having to go through this, I was explaining that in February of 2015, the School Ethics Commission really swung the pendulum pretty far to the right and started making some interpretations that were seen as a little bit extreme. They have started to pull back from those. It appears that there's a new leadership overseeing that group, so I'll give you some examples there. Just as an overview, the Board of Education is the governing body of the school district. You are charged with high-level policy-making decisions. You're the only entity that can enter into contracts or other binding agreements, but your decision-making authority is limited. You cannot administer the schools. Constant theme that we always see in ethics decisions. And unfortunately, boards of ed are hamstrung in that a lot of the actions that the Board of Education will take are conditioned upon the recommendation of the superintendent. It's a symbiotic relationship. The superintendent must recommend, and then it's up to the board to vote. One cannot act without the other. And all board members, everyone has just taken the oath of office here, our newly elected member and our returning members. Everybody is subject to the School Ethics Act, which again I gave to you as tab 3. So each one of the 10 tenets, okay, I did that blindly, wanted to make sure it did change. I've broken down and tried to clarify a little bit. So the first one, and I'm not going to read them to you, I'm just going to summarize them. The first one is to uphold all laws. That's tenet 1. And basically, in order to be found for a violation here, there would have to be a final decision from a court or an administrative agency with a finding that a board member had violated an actual law. It's not somebody's perception or interpretation of the law. It has to be an actual agency or court making a finding that there was a violation of the law. So, how has this been applied in the past? One instance, we had a board member who violated the code when he attempted to issue a rights notice to an employee without following the proper legal procedures of seeking board authority or consulting with the Board of Education. Again, the administration administers the schools, the board oversees. And when you are not in session, you've heard me say before, the board is without authority to direct or authority to act. You function as a team, a 9-member team. Another provision, there was an allegation that the president and other members of the boards were alleged to have violated this provision by holding secret, and I apologize for the typo, pre-meetings to, quote, get on the same page prior to board meetings. Member of the public felt that this was a violation of the Open Public Meetings Act and filed an ethics complaint. The Ethics Commission dismissed and said, first off, one, there was no finding of a violation of the Open Public Meetings Act by an entity that is charged to oversee it, which is the superior courts, and two, the facts as alleged would not constitute a violation of the Open Public Meetings Act. In order for there to be a violation of the Open Public Meetings Act, there would have to be more than a quorum of the board members present discussing board business. Tenet number 2, board members will make decisions in terms of the educational welfare and will seek to develop and maintain public schools that meet the individual needs of children regardless of ability, race, creed, sex, or social standing. Again, I've deemed this the educational welfare provision. Evidence of a violation would have to be shown that a board member willfully made a decision contrary to the educational welfare of the children, or that a board member took deliberate action to obstruct programs or policies to meet the individual needs of all children, regardless of their ability, race, color, creed, or social standing. What is key here is that it can't just be a matter of disagreement. Okay, a member of the public or a fellow board member may have a philosophical disagreement. That does not mean that because somebody voted one way instead of another way, that they're not here for the educational welfare of children. So, here's a kind of egregious example of a violation. A board member was found to have violated this provision of the code when he released an ethics complaint filed against another board member to the media. And that ethics complaint contained confidential information regarding the other board member's child. You kind of see it's petty. It's beneath all of you. You are all been elected by your community to serve. You're very giving of your time and the time away from your families. So as you can see, that kind of pettiness has been frowned upon and is not been found to be not in the educational welfare of children. Another case in point. Complaint alleged that a board member violated this provision by interrupting his presentations before a policy and legislative committee. The member of the public was invited into a committee meeting. The board member interrupted the presentation that was making. The member of the public was advocating for a new football stadium. The board member indicated that they would like to see facility upgrades at one of the other facilities rather than spending money on a football stadium. The complaint was dismissed and was found to be frivolous. A difference of interpretation and application of resources does not mean that somebody is not here for the educational welfare of children. Number 3, this is, we're going to kind of get into the bigger provisions, ones where we see ethics complaints filed and findings of noncompliance, perhaps the most. I will confine my board action to policymaking, planning, and appraisal, the big 3. Board members are limited in their abilities. We have 3 functions: policy, planning, appraisal. Evidence of a violation here would be if a board member took board action to effectuate policies and plans without consulting those affected by them, or they took action unrelated to their duties. So, some examples. These kind of tend to always be entertaining. Here we had a board member conduct a site visit to assess a candidate for assistant superintendent in another school district. So we had a board member take it upon themselves to go view a candidate for assistant superintendent at their current employer, which is far exceeding the policy-making role of a board member. This advisory opinion has caused some stir, and I'll be talking about it a little later when I'm talking about volunteering and the board members' roles in the school. But the Ethics Commission advised that a board member would violate the code, meaning he would exceed his policy-making role if he regularly volunteered for a school club, had contact with and control of students, personnel, resources, and administration. Additionally, he would receive orders from personnel administration. What this was is the board member's wife was the longtime director of a play in this particular school district. The board member who was handy liked to volunteer his time to help build the sets for the play. So he would work side by side with students. The Ethics Commission found that because of this constant contact, that was a violation and exceeded, the limited policy-making role that board members are to play. Now, the Commission has backed away from this a little bit because when this originally came out in February of 2015, there was some serious concerns whether board members would be allowed to go to career day, serve as classroom parents, participate actively in PTOs or PTAs, whatever is in your particular community. So the Ethics Commission has backed this back and has said that not every single instance of volunteering is a violation of the Act. Another big one, no micromanaging. I will carry out my responsibilities now to administer the schools, but together with my fellow board members, see their way are well run. Another way I've deemed this is board members are not to give direct orders to school personnel. That includes senior cabinet, as I mentioned last year, your superintendent, your business administrator, your director of human resources, your other 2 assistant superintendents. Board members don't have authority to give direct orders to employees of the district. Some examples of violations. You kind of see the print gets a little smaller because there's more cases under these types of provisions, because this is where board members kind of tend to trip over their feet a little bit. So the first one, a board member violated the code by instructing the superintendent to allow a graduating senior to participate in the ceremonies where the superintendent had made the determination that the senior was barred from participating due to safety concerns. Another instance, a board member violated this provision of the code when he unilaterally visited the school, took pictures of open windows in the middle school and items in the board office bathroom, which he then proceeded to speak to reporters about. It's not so much the speaking to reporters, but you see it's the showing up of unannounced, it's site visits, it's on-site inspections, again, exceeding the policy planning appraisal. You kind of see that as a theme in all the School Ethics Commission's decisions. Another example, board member violated the code when he unilaterally went to the guidance office, requested copies of the SAT reports, then went to the boys' locker room to inspect the lockers, and then proceeded to sit in the cafeteria and eat lunch with the kids because he wanted to inspect whether or not the food was good that was being served. Again, you can kind of see these are ridiculous examples, but I think they hammer home the point that board members are not to micromanage. Another recent advisory opinion, I know it's got a 2010 date, but the Ethics Commission went dormant and quiet for a 15-month period and then exploded with 38 some odd ethics decisions. So a lot of them sat and were waiting distribution. This one found that a board member would violate the act by participating in exit interviews. That's not permitted. Employees resign, retire. Board members are not to sit in on exit interviews, or more importantly, board members are not permitted to conduct exit interviews because it breaches the obligation to refrain from being directly involved in activities that are responsibility of school personnel. Number 5, no personal promises or private action. Board members must recognize that authority rests with the board as a whole. As I was saying, you are a team of 9. You only have authority when you are together and when you are in a public session. Board members cannot make personal promises nor undertake any private action that may compromise the board. Evidence of a violation here. Board member made personal promises or took action beyond the scope of his or her duties such that its nature had the potential to compromise the board. Some examples. A board member violated this provision of the code when they made personal promises to an assistant superintendent candidate by discussing possibilities, saying, hey, you know, we have an opening, you should really, wink, wink, nod, nod, apply. And your candidacy would be looked at very, very favorably. Again, exceeding, that's a personal promise, not permitted. Board president was found to violate this provision of the code when he unilaterally contacted someone newly hired by the board to tell them that their appointment was void because he had directed the superintendent to remove the name from the agenda, but the superintendent failed to do so. Again, a board member had made a personal promise to somebody else that the job was his, or again, it's kind of obvious. There you see some really egregious conduct. Number 6, no personal gain. Board members must refuse to surrender their independent judgment to special interests, partisan political groups, or to use the schools for personal gain or for the gain of friends. Evidence of a violation. A board member took action on behalf or at the request of a special interest group or persons organized and voluntarily united in opinion and who adhere to a particular party or cause. Other evidence of a violation. That a board member used the schools to acquire some benefit, financial or otherwise, for the member or a member of their immediate family or friend. So, some case examples. Obviously, we just got out of a contested presidential election. There was a significant amount of campaigning. Board members do not lose their rights of free speech. They are free to endorse candidates for election to the board. Board members are free to endorse other board members if they are running for re-election, as long as they do so as private citizens and not as a board member or on behalf of the board, meaning they just make clear that their endorsement is their own and it's not on behalf of the board. Another example, a board member who owned or operated a business could not continue in connection with the Ed Foundation to offer fundraising where students were charged and profits were split between the business and the foundation, as that could be seen as using the school district for financial gain. Another instance, a board member who was previously employed by the district and had been terminated by the superintendent had filed ethics charges against the superintendent and upon being elected called for a vote of no confidence. That would violate the act. If it was found that it would be a violation of the act for a number of provisions, but not the least of which was obviously personal gain. It was a personal vendetta or revenge that was demonstrated by that member. That member was not only disciplined in terms of a reprimand, but that board member was also barred from participating in the evaluation of the superintendent, being present for any discussions, activities, or votes related to the employment of the superintendent directly. Number 7, thank you. Maintaining confidentiality. Board members must hold confidential all matters pertaining to the schools, which if disclosed would needlessly injure individuals or the schools. In all other matters, board members must provide accurate information and in concert with fellow board members interpret to the staff the aspirations of the community for its school. Again, that kind of theme of a team, not a team of 9. Evidence of a violation, a board member took action to make public or to reveal or disclose information that was not public under any laws, regulations, or court orders, or information that was otherwise confidential by way of board policies, procedures, or practices. or other evidence of a violation, evidence that substantiates the inaccuracy of information, meaning spreading false information to the public at large, would also be evidence of a violation. Some examples here. Recent decision, emails to a board member by a member of the public that are subject to disclosure under the Open Public Records Act and are generally not confidential. An allegation was made that a board member had violated this provision of the Act by releasing or sharing emails that were sent to them in their official capacity as a member of the board. The Ethics Commission indicated that as a general matter, I'm sorry to say, emails to board members are subject to the Open Public Records Act, therefore disclosure of them is not a violation. However, a board member was found to violate this provision of the code by publicly posting confidential information that a staff member was removed from the school and hospitalized for a medical condition. Okay, you see the difference there. An advisory opinion noted that a board member would not violate this provision of the code by sending a letter to the editor expressing his opinion about the budget or making a statement to the press, so long as, number one, the letter noted that the board member is making these comments as an individual and not on or on behalf of the board, and that the information was accurate and not confidential. So the maintaining of confidentiality deals with, most of the time, I'll give you a perfect example, dealing with information discussed in executive session, staff-related matters, student-related matters. Number 8, considering the CSA, which is Chief School Administrator, but here in the district you've chosen to name the position Superintendent, recommendation. Board members will vote to appoint the best qualified personnel available after consideration of the recommendation of the Chief Administrative Officer. Again, here, the Superintendent. Evidence of a violation would mean that the board member acted on a personnel matter without recommendation of the Superintendent. Some cases. So this is not a blank check. Superintendent recommends somebody, board members don't have to automatically vote yes. But if you're going to reject the recommendation of the superintendent, it cannot be for arbitrary, capricious, unreasonable, or illegal means. What's some examples of some illegal means? There have been some recent cases where board members declined to vote for candidates because of the color of their skin. Or board members felt that we should only hire males, or we needed to hire African American males. Those are some examples where board members have gotten themselves in trouble, not only under the School Ethics Act, but also in a civil litigation context as well. I'm not suggesting for a minute that has transpired here. I'm just giving some examples. So, some cases. Board member did not violate the code when they voted not to reappoint an employee to the former position despite the contrary recommendation. Again, that's what I was saying. It's not a blank check, but it can't be for arbitrary, capricious, or unreasonable reasons. An advisory opinion recently clarified that the selecting of candidates for district positions and making recommendations is the sole job of the superintendent. Prior to making recommendations, board members are to have no role in selecting candidates for positions other than that of superintendent itself. That has been reinforced recently, most recently last January, and I'll get to that at the end, where really the board's role in the hiring process, in particular even in sitting and being present for interviews, has been severely curtailed recently. Number 9, supporting district personnel. Board members will support and protect school personnel and proper performance of their duties. Again, this includes all board personnel as well as senior administrative staff. Evidence of a violation would be if a board member took deliberate action that resulted in the undermining, the opposing, the compromising, or the harming of school personnel and performance of their duties. Again, these are some egregious examples, but I think they demonstrate the point. A board member was found to have violated this provision of the code when they sent a letter to the superintendent with a copy to the president of the State Board of Education and the executive county superintendent, accusing the superintendent of allowing his employees to violate board policy. Board member violated this provision of code when he sent an email to the superintendent that was also sent to the BA and all other board members. That was threatening, intimidating, in that it asked for the superintendent to provide an accounting of her personal leave. Another instance, the president of the board violated the code by posting the following comments on the Facebook page with a link to a picture of the superintendent. Quote, now if we could only get now if we could only do something about the local terrorist that is destroying our dreams and burning our futures. Again, ridiculous. That board member was ultimately removed from office. Number 10, proceed through the proper channels. Board members must refer all complaints to the chief school officer, again here the superintendent, and will act on complaints at a public meeting only after failure to find an administrative solution. Evidence of a violation would be that a board member acted or attempted to resolve a complaint or conduct an investigation or inquiry related to a complaint on their own. Again, if you receive a complaint from a member of the public, your obligation as a board member under the School Ethics Act is to refer that matter to the superintendent. If the superintendent does not act or the matter is not resolved, it then goes to the board as a whole, not to individual board members. Some examples. A board member violating the code here by going directly to a principal in connection with a parent complaint that he had received rather than referring the complaint to the superintendent. Another board member violates the provision of the code by not providing the superintendent with letters because he didn't like the superintendent's management style. Management of issues raised in the letters. The board member went to other administrators to try to address the issues. As I said kind of last year, you guys remember, you think of it as a funnel. You are the conduit to which the community sometimes comes to with complaints or issues in the school. It's your obligation upon receiving of that information to share that information with the superintendent, and then the superintendent will have it addressed either at the building level or at a district-wide level, depending upon the nature of the complaint and the issue at hand. So, those are the 10 tenets. I apologize if that was kind of long-winded. I give this to you as a reference point. Conflicts, always fun. So you have to love the state of New Jersey in that we have two separate provisions that deal with who can and cannot be present in negotiations. We have the School Ethics Act, which is in the left-hand column, and we have the nepotism regulation, which was adopted in 2008 as a part of, 2008, as a part of the physical accountability regulations. Why you have to love the state of New Jersey is they use the same terms, but define them differently. So it always makes it fun as to try to figure out who an immediate family member is under the nepotism regulations as opposed to the School Ethics Act. Again, same terms, but different meanings. So I'm a visual learner, so I do everything pretty much by charts. So I've given this to you guys kind of as a chart. So it's more of like a Rosetta Stone, if you will. So under the Ethics Act, this is who an immediate family member is. This is who a relative is. And then we have this wonderful thing called others, which until recently was never defined. It was questioned whether that was your godchild, your paper boy, your son's or daughter's best friend, who would be an other. Nepotism was pretty straightforward. You see relative here is a lot more expansive than it is here. So you kind of see how the two could get confused. So I said before we had these others. So within the last year, we have gotten clarification as to who an other is. You'll see that an other is now an aunt, uncle, niece, nephew, grandparent, grandchild, son, daughter, stepchild, etc. And it could be, of course, someone else based on a fact-specific inquiry, which you just, you have to enjoy. Now, these definitions do pop up. If you go back to the 10 tenets, I was telling you, you remember I was saying, like, for example, personal gain. You can't use your office for personal gain for immediate family members, relatives, or, quote-unquote, others. So that's where this all interconnects. So, in context of negotiations, bright line rule. If you have a member of an immediate family member that is part of a unit that is located here in the district, or a member of a statewide union, you're not permitted to be present for negotiations. Again, we don't have that issue right now. We're not entering negotiations. We have good relationships. We have everything is settled and the contract's in place. If a board member has a relative that is a member of the local agency, meaning one of the people that fit that definition before, you're not allowed to be present for any part of negotiations with the local unit here. Those of you that were here last year, and we'll do it again this year, remember we gave out the ethics charts that kind of laid out who can and can't participate and everything so that everybody had it right in front of them and there was no questions or confusion. So, we got some clarified definitions here. Again, if you had an immediate family member in district, you are not allowed to participate. That has remained constant. If you have a relative that is in district, you are still not allowed to participate. But if it's a relative that is employed in another school district, well, maybe you won't be able to participate. The same as another. And yes, if we ever have that situation here, I actually have to sit with you and ask these 3 questions. Is your out-of-district relative in the NJA or local education association? Are they an officer in that local association? Are they on the negotiating team in that other district? Do they have some leadership role in their union? Again, it's intrusive. It's an awkward conversation we have to have sometimes, but unfortunately, this is the rules of the game as they currently exist. I always enjoy having to sit with members and go, well, my niece on my husband's side, who I haven't seen in 20 years, I think just got hired as a teacher somewhere, and I'm not sure what role they might play. So again, you see how convoluted it gets. If board members were endorsed by bargaining units, the WWPEA, the Support Staff Association, or the administrators, in a year in which negotiations were beginning or ongoing, they would not be able to participate in negotiations. This kind of helps to curtail the elect me and I'll settle the contract type of campaign promises. If board members, however, were endorsed in years prior, they're still able to participate. If you have any financial involvement with any entity that does business with the Board of Education, you must abstain on any checks made payable to that organization or in any vote to reappoint or conduct business with that organization. I'll give you an example. One school district, our board president's wife works for the food service provider. That board president every month must abstain on the check that is made payable to that entity, and every year must abstain on the contract that is awarded to that food service provider. The doctrine of necessity is looked at sometimes as this very complicated mechanism. It's not. It basically is invoked only when we have so many people conflicted that we can't conduct business. We don't have that issue here in West Windsor, as we have a board that is almost completely free of conflicts. The interview process, I mentioned before, this is an area where we've seen some tightening. So the Board of Education is free, if it would like, to adopt a personnel committee or another committee, whatever name you would like, that hears actions or recommendations for personnel. It is certainly free for them to do that. But the School Ethics Commission made it clear they do not want board members conducting interviews. There were some school districts where the personnel committee was maybe the third line. First there would be a screening by administration, maybe interviews by the superintendent, and then the superintendent would bring the final candidates to either the personnel committee or to the board as a whole to allow the board to make a decision. We saw this a lot with some high-level positions. I've seen it for high school principals, a very prestigious position in districts, building principals, supervisors of special education, obviously assistant superintendents, business administrators. They made it very clear they do not want the board involved in that role. They gave guidance that if a board does form a personnel committee or a committee under another name that functions as a personnel committee, then no more than 1 or 2 board members can participate and can only have a limited role. They are not to conduct interviews. The final recommendation is wholly within the purview of the superintendent, and they don't want board members having any role in the process except for the selecting of a superintendent. If the superintendent allows, board members can be present to observe interviews but are not permitted to ask questions. Again, the Ethics Commission's position on this matter, again, this is a tightening of prior decisions, is that board members only hire in the district is that of the position of superintendent. Board members, if the superintendent welcomes it and allows it, board members are certainly free to have input. But absent, again, that symbiotic relationship between the two, the board does not have a role. The technical exception comes up a lot in negotiations. There was a lot of questions as to whether or not this still existed. What this applies to is, for instance, let's just say that we had the board's current assistant superintendent for finance had a immediate family member that was a member of another unit. By virtue of the Nepotism Act, he would not be permitted to be present in negotiations. Well, that would certainly hamstring the board, because your assistant superintendent of finance knows your financial conditions, what you can afford, what's in the budget, and this caused a lot of chaos. The Ethics Commission was trying to tell people, well, just go hire a consultant. Well, that's ridiculous. You have people here, and so they have reinforced that in a situation like that, a board can apply the technical exception, whereby, again, in my hypothetical, the assistant superintendent for finance could be present in the back room for negotiations during consultation, but couldn't be at the actual bargaining table. Again, we don't have that issue here in WWP, just making a hypothetical example. Volunteering, I mentioned it before with the poor gentleman who was trying to build the sets for the kids in the play. He was curtailed in that aspect. But you see a more recent one, the very last bullet point here, held that board members are not entirely precluded, rather it's fact specific. They're looking at the frequency and the duration as to how often are you volunteering. Any conflicted board members cannot participate in matters relating to the search, hiring, selection agency, criteria, job description, or vote to advertise, as well as personal matters regarding the superintendent. Why this is here is because there was a tightening down beforehand. The rule used to be if you had a conflict that would prohibit you from being able to participate in the interview process for the position of superintendent, you would be allowed to participate for candidates that were outside of the district, but if there was an internal candidate, you couldn't be present in the room, which was kind of silly because you have board members that wouldn't be able to hear all the candidates. So they've tightened this down basically to say that if you're out, you're out, and they've taken that away. Lastly, shared services. These were a series of advisory opinions. You may remember that the mantra in the state was, of course, shared sacrifice. During the budget crunches in the spring of 2010, shared services was really pushed for the consolidation. You have a lot of districts now, smaller districts, that are sharing the position of superintendent, business administrator, director of special ed, directors of technology, custodial services. So you have a lot of sharing back and forth. There was this advisory opinion that basically said if a board member was employed in District A, and District A sought to share services with District B, and that employee was a board member in District B, that board member would either have to quit their job or get off the board, because they couldn't be involved and serve on the other board because there would be the sharing of services. Thankfully, this past August, that was walked back quite a bit. And the Ethics Commission contradicted themselves. And again, I was saying at the start, we've kind of seen the pendulum pull back. So there was the wild swing with volunteering, and now we're kind of seeing the pendulum fall back with respect to volunteering and with shared services. And I know I went over, I do apologize. Any questions? Okay.
Hey, thank you very much. All right, next is administration. Oh, I'm sorry, committee reports, and we have none. That's right. Administration, can I have a motion on items 1 to 4? Michelle and Isaac. Any questions on the administration items? Items 1 to 4.
Items 1 to 4. Let me find that. Oh, okay, I see. School security drills, school board recognition month. have not read the policies listed under number 3. So, and I'd like to ask a question about the IDEA grant.
Can you speak into the microphone?
I'm sorry. I just have a question about the IDEA grant. What is the IDEA grant? I haven't heard that before. Could you explain
IDEA
that to
grant?
me?
That would, sorry, that would be the grant for individuals with disabilities. It's a grant that we process every year, and there are amendments to it based on further information that comes to us. We apply, and we get certain levels of funding based on the different students with disabilities. So this is just for the approval of the amendment to the grant, because we receive different levels of information throughout the year where we need to process amendments to that grant.
Okay, thank you.
Any other questions? Anyone? Larry?
Yes. No, I'd like to vote yes on 1, 2, and 4, but I have not seen the policies listed under 3, so I abstain from number 3.
Ms. Hope?
Yes.
Ms. Crew?
Yes.
Mr. Wysey-John?
Yes.
Mr. Taylor-John?
Yes.
Mr. Chang?
Yes.
Ms. Cage?
Yes.
Mr. Flaherty?
Yes.
80701. 280 is number 3 has one abstention.
Okay. There are no curriculum items. Finance, could I have a motion on items 1 to 14? Taylor and Louisa. Any questions on the finance items?
I have a question on numbers 8 through, I guess it's 12. Is this camp, is that a summer camp? Camp Canadensis in Pennsylvania?
That would be outdoor education for grade 6.
Outdoor ed, oh, okay, thank you.
And it's actually, I think, just the transportation to it, right?
Correct.
Yeah.
Okay, thank you.
Any other questions?
Ms. Hope?
Yes.
Ms. Crew?
Yes.
Mr. Wysey-John?
Yes.
Mr. Taylor-John?
Yes.
Mr. Chang?
Yes.
Ms. Hurst?
Yes.
Ms. Cage?
Yes.
Mr. Flaherty?
Yes.
8-0.
Okay, can I have a motion on the personnel item plus the white sheet addendum? Wisely and Dana. Any questions on the personnel?
Ms. Krug?
Yes.
Mr. Wysey-Jean?
Yes.
Mr. Taylor-Jean?
Yes.
Mr. Chang?
Yes.
Ms. Hertz?
Yes. Yes.
Ms. Ho?
Yes.
Ms. Cage?
Yes.
Mr. Flaherty?
Yes.
8-0.
Okay, I'd like to acknowledge 3 retirements. We have Nancy Pico, a math teacher at High School South, is retiring after 25 years with the district. John Fresco, science teacher at Grover, retiring after 20 years with the district. And Karen Fondos, cafeteria aide at Dutch Neck, is also retiring after 23 years with the district. I want to thank them and wish them luck in the future. Approval of board minutes from the 13th. Can I have a motion for that? Isaac and Dana. Any questions on the minutes? Those in favor of approval say aye.
Aye.
Ms. Search, you should abstain, just because you weren't a member of the board.
Yes.
Yeah.
Abstain, yes.
All right, and Carol's abstaining.
Yes.
7-0.
Any liaison reports? Any new business? Second opportunity for public comment. Okay. We're going to go into closed session, so I'm required to read this for a resolution. Excuse me. Whereas the Open Public Meetings Act authorizes boards of education to meet in executive session under certain circumstances, whereas the Open Public Meeting Act requires the board to adopt a resolution at a public meeting to go into private session, now therefore be it resolved by the West Windsor-Plainsboro Regional School District Board of Education that it is necessary to meet in executive session to discuss certain items involving personnel issues as noted on the agenda and HIB review on personnel matters.
Mr. President, there's just one amendment. We'll also be discussing in number 7 matters involving anticipated or pending litigation, including docket C34-16.
Okay.
So that just didn't make it onto the agenda, but I just wanted to make that announcement.
Okay. Be it further resolved that any discussion held by the board which need not remain confidential will be made public as soon as feasible. The minutes of the executive session will not be disclosed until the need for confidentiality no longer exists. Further resolved, the board will not return to open session to conduct any business at the conclusion of this session. Can I have a motion for closed session? Louisa and Taylor. Those in favor say aye. Aye. Opposed? Okay, we're going to take a break and then go into the other room, and we're not going to come back out. So, thank you all for coming.